Who's been to the dentist? You all have. Who liked it? None of you have, right? But why do you go? Because you have to. Okay, that is today. I feel like I'm at a rock concert. Oh, did I make it go away?
No, it's okay.
No. Well, I can link if I think of one. I screwed it up, didn't I?
Sorry.
I actually like this look, though.
Yeah, but see, this is what's on the screen right now.
Oh, duh. You know what? I hit something that said swap displays. I think that's what did it.
Yeah. I don't.
You send out the slides afterwards.
I always ask if anybody wants something, maybe like
Not there, man. Doesn't understand. I can't. Not working.
Should we reload it?
Yes, let's just redo it. No, you're fine. I just have to reload it. Yeah, hello. I can't get up to it. Oh, there it is. Okay, sounds good. I'll fix it. All right, there you go. Okay.
Is there any way you can make this big so I can
will.
read it?
Yeah, okay. I'm not used to this computers. There it goes. Okay.
You know what? We can just go this way. I'll just read off that big thing.
Okay.
Great. Thanks. All right. Should we start again? So basically, outlining is the equivalent of going to the dentist. You got to do it. It's good for you. You'll be glad you went, right? All right. So let's just quickly review what we've done so far, because you don't know this, but you guys have done a tremendous amount. You've actually learned a lot so far, right? So what have you been doing? You've been focusing on briefing cases. So this is like the 30-second reminder of what you've been doing, right? You have been analyzing cases at the microscopic level, right? And we've been doing this weird thing called the Socratic method, where we explore your knowledge of each individual case just as to the issue that was presented to the court, right? And it's just a bunch of little case briefs out there, right? Just like little pieces of the puzzle. So what was briefing? It was a legal summary where we focused on the facts, the procedure, the rule, the holding, and the rationale, right? And you guys are starting to really learn what are essential relevant facts versus just stupid facts, right? They're the facts that go to the underlying holding. The decision would have been different, but for that fact. That's a real important skill you guys have learned. Okay, you've also focused on maybe the procedural posture. In the civil procedure, you've been focusing solely on the procedural posture, right? But you realize that's relevant. You've been learning to spot legal issues, which is really relevant, right? Because that's what you're going to do in the real world. Someone's going to come and give you a story, and you're going to have to make a legal thing out of it, right? They're not going to come and say, these are the issues I want you to explore. They're going to come and say, this happened to me, this happened to me, this happened to me. And you've got to say, all right, within that sob story, where are the legal issues? What's the legal ramification of what happened to that person? You're learning to do that by briefing, all right? You're learning to learn rules, and you're learning that rules are generic statements of the law that in and of themselves don't help you that much. But they're nice to know, right? You think that's why you came to law school, to learn rules? Not really. All right, this is why you came to law school, is to learn holdings. And the holdings are how the court applied the rule to a given specific fact pattern. And that is what breathes life into the rule. We know what a rule means only by how a court interprets that rule and applies that rule to a given set of facts. And you're getting good at that. You really are, and you should be proud of yourself. And then finally, and you spend a lot of time in methods on this, and depending on your teachers, you might have spent a lot of time in your other classes on that, is we look for the underlying reasons for the rule, because we've learned what? If it doesn't make sense to apply the rule based on the underlying policy of the rule, the court won't do it, right? And you just wrote a memo on that. We got rid of a whole rule that we hated because it didn't make sense to apply, right? So again, we've learned a tremendous amount of stuff. All right, so what don't case briefs do? They absolutely suck for giving you the big picture. That's the problem. To see the big picture, you have to put the puzzle pieces together. So that's what you have right now. You have a series of briefs, and if I asked you, all right, what's the law of contracts so far? You probably couldn't tell me, but you could probably tell me all the cases you read, right? What's the law of contracts? Outline the law of civil procedure. You can't do that. Why? Because it's all lost within the little pieces. But if you put those pieces together, if you outline all your briefs, look what you get. You get a bigger picture, and you can see the rule, the law. So what is outlining? All right, and this is important. By the time you're third year, it's only one thing, but as a first year, it's two things. So first and foremost, it is a process. It's a verb. I will outline. Have you done your outline yet? Right? I will be outlining this weekend. It's something you need to do, but it's also a result. Thank God I have my outline. I will sleep with you if you give me your outline. That is a noun. You need to do both, okay? All right, so the process. It's by doing outlining that you learn the law. You're putting the pieces together, and by putting the pieces together, you'll see where things fit together, right? And it's a pain in the ass, but it's kind of cool. You'll actually say, God, I get it now. That's what that case meant. That fit here. Oh yeah, that case is just a part of another rule, right? So you'll understand that rules all of a sudden will have elements. Rules might have exceptions, right? We saw that with the Pratt case where they added the exception to the immunity doctrine, right? You'll see there might be defenses. In torts, you'll see that a lot, right? You'll learn there's majority views, minority views. There might be a restatement view. There might be a common law rule. But you don't really learn that until you start putting the pieces together. All right. Then what's the result? The result is when you're done and you have a nice, clear statement of the law. And you'll have three outlines, right? Contract, property, and civil procedure. So when you're done, you'll have a little baby treatise of the law of contracts, contracts, civil procedure, and torts that you can then use for your law school finals, okay? So we're taking the rules, the policies, and the holdings from your cases and putting them in an order that will make it make sense to us from the big picture. All right, so how do I do it? All right, number one, most important thing, we're chucking our briefs entirely. We're organizing around topics, rules, causes of action, and defenses. Big things, important things that will make sense to us, right? So, and be real smart about this. Don't just write down law. Pull back from it and give yourself context, because the law doesn't make any sense if you don't understand what it's applying to, right? So, when you're outlining torts, think broadly, like, okay, there's the mean torts. What are those? Well, those are the torts where somebody does something intentionally. Battery, assault. So maybe those fit in one place together. And then there's the stupid torts. What's that? Negligence. People who were stupid, right? So, but that's different than mean torts. And you can just start outlining them that way. When you're doing civil procedure, and you just have all these weird rules that are hanging out there, this personal jurisdiction crap and all that stuff, if you think about why that rule came about and where it fits into the larger picture, it will make sense. And if you guys haven't figured this out, look at your Civ Pro book, just the rules. And you start at 1, and I don't know how many are there. How many are there? Like a lot, right? I mean, more than 70. Those almost go chronologically based on what? You thought about that? The way a lawsuit flows. So you punch me. I'm mad. I sue you. So where do we start? We look at the rules of civil procedure. What's the first thing I have to do if I want to sue her? I got to find a court that will hear it. What's that? Oh, subject matter jurisdiction. Then I got to get the court to obtain jurisdiction over her. What's that? That's personal jurisdiction. So put it in order of what's happening. It will make sense. Okay, now I got a court that can do it. How do I get the court to have jurisdiction over her? Oh, I have to serve her with process. Oh, I get it. How do I do that? Oh, Rule 4, a complaint. Once I serve her, what does she have to do? She has to what? Answer. What does she have to do to answer? You just keep going down. Once she answers, what do we do? Well, she can file a motion to dismiss, Rule 12B. We just keep working our way down, right? Then I got to find out what she has, hidden in her bedroom closet, so we start discovery, Rule 26 on, right? Then we want to get rid of the case, Rule 56. It's just all chronological. So if you think when you're doing the outline how it all fits together, in terms of contracts, just don't think of rules, like think, oh, how do I make a contract? Outline that. How do I breach a contract? Outline that. What happens if someone breaches? Oh, damages. Another section, right? So really try and pull back and get the big scheme of how things work. It will make so much more sense. And more importantly, when you get a fact pattern, you'll recognize the issues, right? Rather than just having a rule that's hanging out there in space, you'll have a rule that's attached to a fact pattern that will then make sense when you see it. All right. So we're not organizing around cases. You're done with your briefs. We hate your briefs now. Throw them away. We're taking the rules, the policies, and holdings. We're sucking the good crap out of the briefs, and we're putting them in order. So we're going to start ordering them around rules rather than case names. So about 90% of your briefs are now irrelevant. What's the only thing we care about from your briefs for the most part? The starts with an R and starts with an H. That's all you need, right? Okay, and I'm going to show you how that works in a bit. So for each topic, you really want to start with the main rule. Battery, 1, 2, 3, right? Contracts, 1, 2, 3. What's the main rule for each one of your main headings? Number each element within the main rule. Why are we doing that, right? We're writing an umbrella rule, and we want to know what the elements are. So to make sure you memorize them, I would capitalize and bold them, and I would number them. So here's an example how you might write the rule for contracts. Contract requires what? An offer, acceptance, consideration. Some of your teachers might add a fourth, mutuality, right? Maybe you have to have something else, I don't know. But list the elements that your teacher wants to see in the main rule, okay? Then notice how I'm citing the case name there, case/restatement/UCC. What's that? That's the citation that proves the rule. But notice how instead of saying, I learned that rule in case Jones versus Smith, rather I care about the rule and I'm only citing Jones v. Smith for the proposition that proves the rule. So I'm focusing on the rule of the case. I could care less at this point about the case, okay? All right, and then next you're going to have a subsection that defines each and every element within the main rule. So how many subsections will you have for that rule? 3? Good. Why? Because you have 3 elements. You're going to have to define each and every one of those elements independently so you can develop each one in a separate IRAC later. All right, so here's how it might look. Contracts, 1, 2, 3, then you're going to break it down. You'll have a section for offer. You want to know what an offer is, so you'll define that rule. Then you'll cite a case or the restatement that proves that rule. So I now know I got 3 elements to prove if there's an existence of a contract. I now know I got to argue whether there was an offer. I now have a rule for what an offer is. All right, then what do? Once you've fully defined the element of the main rule, this is where you then put your case cites and your holdings. Or if your professor says anything important, put it there. If a student says anything important, put it there. That's the first time we care about the holding of a case. And why do we care about the holding of the case? It's the holding of the case that gives us what? A picture of what the rule is. And that's going to give us the ability to make a comparison when we're analyzing whether that rule applies or not to our given fact pattern in our hypothetical, right? Okay. So here's how it might look. A, offer. Boom, definition, state the rule, and then, oh, I had 2 cases on that. Jones v. Smith, what was the holding? No offer when these facts are met. Oh, wait, we had the James Hayden case. There was an offer when these facts were met. So what does that give us? That gives us the parameters of when there will be an offer or when there won't be an offer. And that's the holding. You already done offer, right, in contracts? And you've already seen when an offer worked. Too vague, something like that, right? No meeting of the minds. I mean, there could be some reason for that. What's the key fact that proved that? Get that into your holding, because why are those relevant? Because you're going to get a fact pattern in your hypothetical, and you're going to have to decide whether there was an offer or not. And to analyze whether there was an offer or not, you're going to have to compare it, and there's going to be a lot better analysis if you can say, we're like Jones, we're not like James, right? But if you don't have that there, it won't come back to you. So that's the first time you're ever going to really mention a case, is after you define the rule. So I would have done a 3-element rule here, but I ran out of space. But assume you have a main rule, you then cite the rule, then you'd have a subheading for that element, you define that rule, holdings from cases, professor's comments, B, subheading element 2, rule, boom, boom, boom. Make sense? But notice how we flipped everything. The cases now are buried down here, and it's not so much the name of the cases. What's central? What you need out of the case? The holding, so you can analyze the rule when you're making your fact analogy. All right. So why do I outline it this way, right? Because it's not easy, because you kind of have to, you have to put all those little pieces together, and it's very time consuming. All right. We want to do our outline in a way that will best help us, what? Perform well on our law school exams. So let's look and see what the teachers are going to look for when they read our law school exams. They are going to give you a hypothetical situation, like a client coming in babbling to you with a series of facts. And they're going to expect you to spot all the legal issues that that fact pattern generates. They're then going to want you to expect you to know the rules that originate from those legal issues. Then they want to see if you're smart and can analyze whether that rule applies to your fact pattern or not. And then the absolute least important thing is they want you to conclude whether you think it would or not. So 4 major steps, right? Can I spot the legal issue? Do I know the underlying rule that's generated? Can I apply the rule to a fact pattern? And then am I pretty good at guessing what the professor wants on the answer? You can get an A, I guarantee you, right? Right there. If you never get C right, you still can get an A. If you get all the issues, you get the rules, you get your application, you're going to do just fine, even if you guess wrong on the conclusion. All right, so watch how you do this. If you do your outline right, you have to do absolutely no thinking in finals. And I'm all for that. Because no one thinks very well under stress. So let's do all the work beforehand. And then honestly, taking the test is simple. So you laugh, but it's true. All right, so an outline. What do we have? This is the outline that we just did for an offer, right? So we have a heading, offer, right? Then we have a rule, an offer is. Then we had 2 holdings. No offer when, right? And then, your contact professor said something cute. You want to work that in, make sure they thought you were listening. Look at the test structure. IRAC, right? I-R-A-C. If you have outlined your rule exactly like I told you, you literally can slide the template into your law school exam, and you don't have to do a damn thing except write 1 sentence at the end. Watch. All right, what's your heading? What does your heading become? Flip it into a question. Becomes your issue. Was there an offer? What's the rule? Slide it over. An offer is, boom, right? What comes next? Your application, right? You've already got the case comparison. Slide them over. You now have the 2 cases that you can use to compare as to whether your fact pattern generates the offer or not. So the absolutely only thing you need to do, if you've memorized your outline, is simply analyze, is my fact pattern more like Jones, or is my fact pattern more like Hayden? Got it? That's why you want to do an outline, because it literally is the template for making a legal argument, or in your case, and right now, setting up an IRAC on a law school exam. All right, so here's some tips. Number 1, write the rules in your own language. Don't change the elements. But I dare say none of you right now could tell me what the UCC says. Have you guys read the UCC? You got Peterson? Do you think he digs the UCC? A little too much, right? It's kind of creepy. The whole point here is what? Somehow you got to be able to spit back what that UCC means on the paper. So just because you type it out doesn't mean you know it. So how do you get that into your own brain? Put it into language that you can repeat. You do not know what a rule means till you can sit by someone on tracks who hasn't go to law school and explain to them what the rule means. Hey, you look bored. You look homeless. Let me tell you what an offer is, right? And if they go, okay, you're there. All right. So quickly read this. An offer is the manifestation of a willingness to enter into I just pulled this out of a restatement. An offer is the manifestation of a willingness to enter into a bargain so made as to justify another person in understanding that his assent to that bargain is invited and will conclude it. That's pretty damn clear by restatement standards. That's pretty damn unclear by human standards, right? Somebody tell me what an offer is based on that rule. Got to think. Is it coming back to you? What are the elements in it? I don't know. Why? Because it's a stupid-ass rule. Make it make sense to you. What are the key things you'd have to argue with in that rule? Put it in your own language. And I did this last night, and it totally sucks. But you could do better than this. But there's got to be some form of a communication. I got to talk to you, right? And it's got to be done in a way that's expressing my willingness to enter into a contract. But it's got to be phrased in such a way that you understand if you say yes, we just made a contract, right? So put it into your own words in a way that you can explain what each and every one of those rules mean. And then you've got it for life. It will never go away. And that's why I mean the process of outlining is so important. If you just steal somebody's outline and all they've done is retype the restatement rules in there, you won't know it, right? And you'll try and read it and you won't get it. It's when you write that rule, then you rewrite it to make it human, that you actually learn what's in that rule. Okay? That's probably the most important thing in this whole slide there is you do not know what a rule means until you can tell somebody on a bus what it is. All right, and then you just repeat that process for each and every stupid topic you've got in all three of your courses. So basically, what are we doing? We're breaking it down. Issue, rule, cases for application. That's it, over and over again. All right, so who's done personal jurisdiction minimum contacts so far? Anybody? Who's not? Okay, who's not sure? Okay, I'm going to quickly outline it very quickly for you. You cannot trust this because I was going off what I remembered it to be a long time ago. There wasn't the internet back then. I think there was only 32 states when I took civil procedure. So this is to give you an example of how to outline, not what your outline should actually have substantively, all right? So if you rely on this, you know, caveat emptor. All right, here we go. So start with your big heading. What's your big heading? Oh, that comes in civil procedure, right? Now that sounds stupid, and it is stupid for law school, but why isn't it stupid in the big world? When you take the bar, it's easy when you take Civ Pro, right? Because you think, I'm pretty sure I'm going to get a Civ Pro question. But when you take the bar, you're going to be tested on 22 different issues, areas of law, and they don't tell you what the issue is. And it's really scary how much like property law will overlap with contract law, will overlap with agency law, that will overlap with trusts and estates. So you really got to pull back and first of all say, all right, what's the big issue here? Okay, but pretty easy, at least in law school, because you only have 3 things to outline. Then, okay, well, that kind of personal jurisdiction obviously fits under a broad heading called jurisdiction. But wait a second, there's 2 types of jurisdiction, right? There's subject matter jurisdiction and there's personal matter jurisdiction. So we're going to want to break those out into separate topics. Then you'll have a nice little heading for subject matter jurisdiction. And this is just where you'd start. I haven't tried to outline that for you because I couldn't remember. But if I remember right, there's rules for state jurisdiction and rules for federal jurisdiction, right? State's general, federal's limited. You got to have what? A federal question or diversity to get into federal court. So you'd have rules for all of that crap, right? Then we get down to personal jurisdiction, right? Subject matter is just getting a court that's willing to hear your case. Personal jurisdiction is, okay, I got a court that's willing to hear it. Now I got to get them to exercise jurisdiction. I got to trick that person into coming to court so I can grab them, right? Because once I got them, then they have to listen and talk to me. They got to answer my complaint. So we're going to talk about personal jurisdiction. All right. So I now have a heading for personal jurisdiction. See how the rule's working? 1, A, subject, B, personal. Okay, actually, what's wrong with that? That was a 3 o'clock in the morning mistake last night. What's wrong with my top heading there? Should it be a B? Should be a B, not an A, right? Okay, so see, don't trust me. All right, so number 1, have we learned that you can get personal jurisdiction by consent? If someone shows up in the state and you grab them, you got them. They just consented. Somebody could always say, sure, I'd love to be sued. I'll accept personal service, right? And actually there's laws that require corporations to have their personal agent accept service on behalf of the corporation. I don't know if you studied that, but it's an important law if you sue corporations. So there's a lot of different independent rules on when somebody might consent to jurisdiction. But as a general rule, people don't like to be sued, so they try and avoid process rather than accept it. So we have another heading called, okay, I can grab you by what? Service of process. And we have people called process servers who do that, right? And you have a whole set of rules on how you have to do it. Does anybody know the rule quickly? Can't be a party, you got to be 18 or older and something like that. All right. Now we have learned that there's different rules if you serve someone in state, right? It's a shorter time period, that sort of thing. But we also have a set of rules for how we serve somebody out of state. And that's when the Constitution kicks in. Why? Because it's not necessarily fair to sue someone in Saudi Arabia and ask them to come all the way to Salt Lake to defend a lawsuit when I got into a fender bender with them in Saudi Arabia. So there's these limits placed by the Constitution on out-of-state service. So that's what I want to talk about today is personal jurisdiction when we're serving somebody out of state. What do we have to do to make sure we don't offend the Constitution? All right, so we're now going to have a heading called constitutional limitations. And that's called what? Due process concerns. And have you done the minimum contact rule? Okay, so we have a heading for due process concerns. What's the main rule? To meet due process requirements, if we're going to force somebody to travel all the way to where we live to defend themselves in a lawsuit, we have to do what? We have to prove that they had minimum contacts with our state in such a way that it would be fair to have them defend themselves in our state. They have to actually have sort of what? Shown up in our area. It's not fair. Somebody in Saudi Arabia has never heard of Utah. It's really not fair to make them fly 18,000 miles. But if they've been hanging out in Utah, maybe it is. So we're now looking at minimum contacts. So what? That becomes our sub-rule. Due process, you got to have minimum contacts. Well, what the heck does minimum contacts mean? Let's define it. And if you've read it, you already know this, right? First of all, we don't look at, when we're trying to decide whether due process is met for service of process, we don't look at the plaintiff. It doesn't matter, it doesn't matter that I've lived here for 30 years. It matters what the heck the defendant has done. So we're going to look at the defendant's activities on contacts, not the plaintiff's. And then the court defines it. And notice how I've done two things here. That's the rule I stole from Hansen. Do you guys still read Hansen? Is that still good law? Okay. So I wrote the rule that defendants must have purposely availed himself of the privilege of conducting activity in the state, thereby invoking the benefits and protections of that state. That's the rule. If you have a take-home test or you can bring in your outline, I'd just copy that rule, quote it, and type it back down. But that's too long for me to remember. If it's an open book test, I want to simplify it. And so what's the whole point there? I got to remember, we're looking at the defendant. The defendant has to have done what? Purposely availed himself. I can probably remember that, right? So I tried to simplify it in a way that will come back to me. And if I can remember purposeful, I can probably remember avail, probably remember benefits. I can remember some of that other explicit stuff. But I've tried to simplify it in a way that will most likely, if I do that again, I'm turning my finger off. It will come back to you when you're panicked under time constraints of an exam. All right, now, up to now, what have I done? Look at all this crap, all right? Big rules, big rules. First time I've cited a case was under the main rule for defining due process is minimum contacts. International shoes where that came from. No facts, no holding, no nothing. I just want to know where that rule came from, okay? Now we come down, and I've learned that there's a sub-rule that defines minimum contacts as purposeful actions on behalf of the defendant to avail themselves of the benefit of the state. Okay? Again, I'm just citing the case name because I want to know where that rule came from. But now what do I want to know? This is the point where rules no longer work for you, and you got to use holdings. How do we know what purposeful means? We have to look at what the court held to be purposeful and what the court held not to be purposeful, right? That's where the holdings start breathing life into the legal definition of what is purposeful. So for the first time, I'm now going to take all the holdings I've looked at in all my cases and just start listing them. And I might do a little chart. Purposeful found, purposeful not found. Why? It's going to set up your analysis and your counter-analysis for you. So let's just take a look at some of the cases. And this is exactly the way you shouldn't do it. I just put international shoe up there, but I'd actually move that case name to the bottom. And that I'd start with held, purposeful conduct found, right? Because that's going to give me the comparison when I'm looking at my fact pattern. Are we going to be like international shoe or not? Well, if we are, what? They purposefully availed themselves of the privileges of acting in that state. So what are the key facts that I want to pull out of international shoe? What? They held that purposeful conduct was found. Why? Because a Delaware corporation, that sole office was in Missouri, did what? They solicited business in Washington, they sent their salespeople there, and they earned money there. And the court said, okay, if you send people to earn money in a state, it's fair for you to go there and defend yourself, right? You have what? A connection with that state that you intentionally created. So those are your key facts. That's the only thing I would suck out from the entire international shoe, because that's exactly the facts you're going to want to work back in when you make your analogy. So we now have a nice example of what is economic benefit, earning money, sending people there. That's going to be purposeful. Okay, now we got another case. I don't know if you guys did this case, but this case found that there was no purposeful conduct. And that was a divorce action. The father lived in another state. The mother lived in the state, wanted to sue the dude. And he allowed his kids to visit his ex-wife, just to be a good guy. And she said, oh, you're sending the kids there. That's enough that you now can come to my state when I sue you. What did the court say? No purposeful conduct. And what's the key language? He didn't do a darn thing. He merely acquiesced in her request. He didn't earn any money. He wasn't generating any income. All he did was allow his kids to travel there. That's clearly not purposeful. So do you see that we now have the parameters? Acquiesce, no economic benefit, no purposeful. Intentional sending salespeople there, generating income, purposeful. So we now have the parameters of what we start to understand would be purposeful conduct, which would prove what? Minimum contacts. We're working our way back up. Then we get another case. Now we're dealing with businesses, ick, and we're dealing with international businesses. So here we have Volkswagen. Tell me this isn't relevant today where every state is suing Volkswagen for the diesel issue, right? It's going to come back up. So in this case, the court found no purposeful conduct. And here was an Oklahoma car dealer, not an Oklahoma car dealer. It was a New York car dealer selling cars in New York and the Northeast region, but the owner of the car drove to Oklahoma and got in a wreck. So they sued the New York car dealer saying, wait a second, the car you sold in New York made it to Oklahoma. That's enough to create jurisdiction, right? And what did the court hold? That's not enough, right? It's not enough that there's a chance that you would derive revenue because there's a chance your car might end up in Oklahoma, but you as the retailer didn't intend your car to go to Oklahoma. You were just selling it to people in New York. So again, not purposeful enough. Now, our next case. Have you done this one? Okay, I don't know how to pronounce that. But this was where the court split. And here the question is, what if you had an international company and they were shipping crap to the United States? The question there is that purposeful? So some of that crap they ship to the United States comes to Utah. And the court split. They couldn't decide. Was sending it to the United States enough because it might derive some general benefit? Or did the international company have to intend that the crap it shipped actually get to Utah? And the court couldn't quite figure out which way to go. It was split. So do you see do you see where you might get a hypothetical? You get a hypothetical. That's right now you're at the cutting edge, 32 years ago anyway, of where due process started to break down. Court isn't sure. So you're going to get probably a hypothetical, if this was all your law, on an international company that sent something to the United States, it made its way to Missouri, and the question is, could the Missouri court require that international company fly all the way to Missouri to defend themselves? All right. So if I just outlined that for you, look how easy it would be. I'm now giving you a test question. Somebody in Switzerland, right, sold a Rolex watch in New York to someone who bought the watch in New York, drove to Utah, the watch exploded and blinded them. They want to sue Rolex and make them come all the way to Utah to defend themselves. So, beautiful issue of what? Would that violate due process to make Rolex, who only sold watches in New York, come to Utah because their watch somehow made it to Utah? So let's take a look at our outline. What's the heading? Can we obtain personal jurisdiction over Rolex, or would that violate due process concerns? What's your issue? Can we sue Rolex, right? Because due process concerns. What's your rule? Minimum contacts must be purposeful. What's your rule on your test? Minimum contacts must be purposeful. What are the cases we learned at that flush out what purposeful means? International Shoe, Worldwide Volkswagen, Ashashi, right? We have all three cases. Slide them over. We make our comparison. So what's the only thinking you have to do in that entire hypothetical? Is the fact pattern your teacher gave you more like Worldwide Volkswagen, an International Shoe, or more like Ashashi? Right? Very simple. Is that easier than if I just gave you that hypothetical and you had those four briefs to look at, International Shoe, Colco, Worldwide? Would it come back to you fast enough? It wouldn't. You think, what was in that case? There's a rule somewhere there. There's a holding somewhere. You suck out all the good stuff. Those cases become irrelevant. Your outline becomes the template for your exam. Do the work up front. Taking an exam will be the easiest thing you've ever done in your whole life. All right. So you've already done this before. You've already done it this year. You've already outlined two subjects. You already right now know more than any lawyer in town, because they're bizarre rules, on these two rules. What are they? You don't even know you did it. See, that's how smart you are. Who is now an expert on whether a minor can disaffirm a contract? Right? You know, what did you do? You laid out the big rule, right? You had to do this and this and this and this. And what did you do? You broke each element down, you defined each element, and you looked at how the cases interpreted the element. So if you ever get an issue in contracts, which you might not, But say you had an issue on whether a minor could defer a contract, you had everything you needed to make the analysis, right? And you just wrote a memo on another one. What? Can you sue a canal owner if someone drowns in their canal? You laid out the rule, you broke it down by the elements, right? You analyzed what each and every element means. You now know what inherent in a canal totally means because you looked at 4 different holdings that defined it. You have totally done all the outlining. Every skill you did in there, transfer it to your other classes. You're ready to rock and roll. All right, so I'm going to answer all your commonly asked questions, and then I'm going to open it up for more questions after. Number 1, where do I start? Your table of contents in your book is a great place because if you look at the headings of each chapter you start to read, those will be the big headings for your outline. The subheadings for each chapter will be your subheadings, right? So if you want the best template for your professor's class, it's the casebook that professor gave you. Commercial outlines. Have any of your professors told you to stay away from these? Have they? Some do. Okay. So are we being recorded? You can trust them if you want, or you can do it the easy way. I would say it's not a bad idea to have a commercial outline as a baby blanket, because it is really hard to take all those case briefs and figure out where they go. But if you can start with a skeleton that is already created and slip your cases in while you're rewriting them in your head to make it work for you, that's a lot easier. Why reinvent the wheel if the wheel's out there? That being said, and what I agree with all your professors that tell you not to use them, if you just rely on a commercial outline, you can get in deep trouble because you haven't actually done the work yourself, and that outline might not totally match exactly the way you got it taught, right? So a commercial outline gives you the bare structure to use, which is very helpful, but you're going to want to tweak it, A, for your professor, but more importantly, to make it sure it works for you. And then this is either the best or the scariest thing of all time, student outlines. What's better about a student outline than a commercial outline? It will be tailored for your specific class. The frustrating thing about a commercial outline is it might lay out the rules for you, but it won't use the exact cases you studied, and that will be frustrating for you. It might be laid out in a totally different way than your teacher did. But if you get an outline off it's not the SBA side, it's the commercial litigation-y thingy. Does everybody know about that? Okay. It's well worth getting. Then you can have a tailored outline for your professor. So what I usually tell people is get the commercial outline, get the student outline, cross-check them against each other, then take those two, make your own outline somewhere in the middle. You can't go wrong if you do that. What's bad about student outlines? They're student outlines, right? I mean, they're wonderful as far as they go, but you're still students. So to some extent, don't bet the house on it, right? Use it. If it doesn't make sense, it's probably wrong. All right. And a perfect example for that is I once, being like the genius I am, my buddy and I decided, well, why should we outline everything? So we decided to, I'll do half, you do half. And then being even dumber, we waited till the 2 nights before the test to exchange the outlines, thinking, oh, we can just memorize them. And my buddy is 10 times smarter than I am. And I looked at his outline and couldn't understand a thing he said. And he ended up getting straight A's. And I couldn't understand a thing he said. Why? Because we think differently, right? I mean, so I literally had to rewrite his outline in my vision English. I didn't get it. So it was totally worthless to me, right? So that's why you got to start early, and you got to make those outlines your own, or they're entirely worthless. All right. So what do I do with my outlines? Memorize them. Memorize the big picture, memorize the elements, memorize the holdings. And that's very easy to do if you've done it in an outline format that's logically structured. Then, before the exam, I would take those bigger outlines and condense them down just to bullet point headings and just bing, bing, bing. Contract, 1, 2, 3, offer, element, acceptance, element. So it literally is a cheat sheet of the big rule and all the elements without all the fuzz. Why do you want to do that? It'll come back to you quicker. If you can't bring your outline in and you have a very long and detailed outline and you have to sort through hundreds and hundreds of pages, you're going to get lost in the details and it might not come back to you. But if you have an outline that you can just literally in 2 pages envision what's in your head, it will come back to you much quicker. And if you can spot the issue, the details will come back. Where students get in trouble is they get lost or mired in the muck and they miss the issue because it doesn't jump out at them. So write this down. I don't know if you guys have computers. You're not allowed to bring computers to these things? All right, do you have pencils? Do you guys even have pencils anymore? All right, if you don't have a pencil right now, I want you right after this is over, once you wake up, go to your Carol and write this down. How many issues can there be in a law school exam? You got the teacher by the ears if you learn this. They think they're so cute at hiding issues, and they will go out of their way, staying up at night, giggling in this sort of sick, mean way of how they can hide a consideration issue in contracts on you. And they're good at it. How can you make sure you never miss an issue? How many issues can your professor ask? Only as many as there are rules. If you memorize every heading, every issue's got to be a heading. It's got to be in torts. What does it got to be? It's got to be one of the intentional torts. It's got to be one of the negligence torts, right? In contracts, what does it have to be? Well, did they have a contract? Did they not have a contract? Did they breach the contract? It's got to be something like that. So if you can literally envision, all right, there's only 7 intentional torts here, right? Okay, I got that. It's not that. You can literally use that outline as a checklist to work through the fact pattern and go looking for issues, right? I don't know if I mentioned this. Did I mention the pregnant baby at the sperm bank in my last lecture? No? All right. I mean, back in my day, we didn't have computers, right? And the teachers were even sicker than they are today. And I distinctly remember these 2 law school exams. One was, it was in torts, and a racist went to a sperm bank, I told you that, right? And wanted a white baby, but got a black baby, got black sperm, right? So again, that's like, where did that come from, right? But if you have your outline, work through it. Spot the issues. What could they be? It's either got to be, could it be negligence? Probably, right? Oops, missed the vials there, mixed up the vials. What else could it be? Work through all the intentional torts you've learned. What could it be? Battery? Great one. What else? Intentional infliction of emotional distress? Maybe. Assault? Probably not, because you didn't see the sperm going in, so you weren't put in fear. What else? But that's exactly what you got to do. You got to work through each and every issue. But you won't miss any if you think, my God, it's only got to be 1 of 6 intentionals or negligence. Can't be anything else, right? And then in con law, I'll never forget this too. It was a 32-page law school exam, and we only had 4 hours to answer it. Did I tell you this too? Okay. Half the class walked out. It was a series, back then the environmental laws were just coming into effect, and they had just passed this thing called the Clean Air Act that Trump's getting rid of. And the whole concept, they were incredibly complex. I mean, I didn't understand a damn thing in them. And it was for constitutional law. And it occurred to me that was strange because this was that was an environmental question, and I was in con law. And everybody just freaked. But if you have the bare bones outline, you work through it. What can it be? What constitutional issue could arise from an environmental statute? Separation of powers? Maybe. War powers? Nah. Personal, freedom of speech? Nah. You work through it and you just keep going down. And it finally occurred to me, Commerce Clause. The whole question was, did Congress have the authority to write the environmental statute? Had nothing to do with what was in the environmental statute. You could have just skipped, once you thought of that, all the way to the end of the exam and wrote it. But I wouldn't have thought of that had I not had that cheat sheet. Said, okay, there's only 9 issues in con law. It's not a personal thing. It has nothing to do with a foreign country. You just work your way through it, right? It has nothing to do with the president. It has nothing to do with the courts. So, I've already got rid of Article 1 and Article 3, right? Or Article 2 and Article 3. It's got to be in Article 1. And then you work your way down through the Article 1s, and you think, it's not taxing power. It's got to be that. So again, you can't have more issues than you have rules, and you can't have more sub-issues than you have elements to the rule. So once you get your outline done, you got the parameters, there's no way your teacher can hide a damn thing on you. And they will try. When should I start? Soon. That's why we do this now, because we think it's a pretty good time to start thinking about it. For those of you who have started outlining your other classes, that's great. But for those of you who haven't, fine. So fall break is not a bad time to start thinking about it, right? And I wouldn't wait too long, because as that pile of your cases gets bigger and bigger, it just gets more oppressive starting, right? So start earlier than later. A little bit at a time, because like going to the dentist, the time that it takes to do it is magnified because it just seems so unfun. Okay, when should you do your outlines? I generally think you should kind of try and do it every time you finish a chapter, because again, it's kind of fresh in your mind, right? And then you can put it aside. And remember, you're just putting things in order. What I want you to do now is understand it, but not necessarily memorize it. It's way too soon to memorize stuff, you just forget it. So okay, I now understand what consideration is. I can forget about it. Now I got to go on to whatever the heck the next thing is, right? And so just keep working that way, because once it's in your outline, you'll have during dead week probably a couple days before each final, so you can then go back and memorize everything you've done in your outline, because you don't have to learn it because you've already outlined it, right? But if you wait and it gets longer and longer and longer, it just gets harder and harder to outline. And what you don't want to do is be outlining during dead week, because it's hard to learn and memorize at the same time. There's just too much input going in. So if you can just sort of keep up on your outline, then just memorizing the crap out of it and doing some practice exams, it's just like a breeze. All right. Do I need case names or citations to the UCC? Generally not, but ask your professors. Some care much more about it than others. In con law, there's fewer cases, right? Everybody knows Roe v. Wade, Marbury v. Madison, there's the biggies. So it's kind of cool to know those. But there might be a gazillion cases that define what consideration is. So to the teacher, that's not relevant. What's going to be relevant? What the elements are for consideration, right? So again, ask your teacher. How long should it be? Really size, the longer, as a general rule, the worse. But one of the saddest moments I've ever had teaching, and I have had a lot, it's always the gunner that does this. She came in maybe 2-3 days before the final started, and honest to God, her outline weighed 55 pounds. I mean, it was this big. She had typed in damn near every comment from the UCC. She had typed in every provision from the UCC. She typed in every common law provision, every comment any professor had ever made. I mean, she could have sold this to somebody in a foreign country, right? It was incredible. And it occurred to me what? She had never taken the time to simplify it or understand it. She had just typed in everything without thinking. That's the worst thing that a law student or a lawyer can ever do, is actually work without thinking first, right? So I shouldn't have done this. It was cruel. And it's lucky she's alive today. But I simply said, great outline. What are the 3 elements for a contract? Couldn't do it, right? So if your outline's that detailed and that great, that you don't know what the 3 elements for a contract is that a good outline or a bad outline, right? You want the outline that when I bump into you in the parking lot, I say, hey, how many intentional torts are there? You can bang them out to me. You want that ability to see the rules and the elements in your brain. The details will come back to you. But if you're mired in the details, you'll miss the issues, okay? All right, so what's the best format? I just told you that I love outline format, but a lot of you think very differently than I do, and that's absolutely fine. So, outline for a lot of you, but a lot of people like flow charts. They're very logical. If this, then you go here, then you go here, then you go here. It works great for contracts sometimes. It's great for con law, and a lot of the study aids you'll buy might actually use a flow chart. I look at a flow chart, my mind shuts down. Some people, though, like science people or economics people, are used to looking that way. Great. Charts, diagrams, elements just listed like that, great. Flashcards, if you got Tommy, a lot of people suggest flashcards are good because he tests more on the specific hypotheticals where you don't actually have to spew out a rule back to him, right? Though I still think it helps to outline for him, because if you know where that sub-issue that he's actually analyzing fits, I think it will increase your odds of guessing right. All right. Do I really need to outline? All right. Are study groups helpful? Maybe. If you exchange separate outlines, do it early. Don't be me, right? Working together to create an outline is not a bad idea, right? Because again, you can do it your way. You're there to hold each other's hand when you want to cry and get depressed. But again, make it work for you. And if your study buddy thinks differently, don't worry about it. Do it your way. Let them do it theirs. But if you can get mutual support for that, fine. But again, if you start getting in arguments, you start getting in pissing matches, things get worse. You start talking about other people. You start complaining about your teachers, especially me. You're wasting your time, right? So at some point, you really need to do it yourself. So if you can do it that way with somebody, great. But if you're just sitting around in a group talking and thinking you're doing something, but you're actually not putting that shit down on paper, and that shit's not going into your head, you're really wasting your time. All right. Any questions? Come on, just ask one. Extra credit for somebody in my class if they ask a question. Yes, thank you. If anybody wants these slides, email me, I'll send them to you. Okay? Yeah.
The weekend wasn't packed, I promise.
I felt awful about that. I felt awful. I'll make it up to you, I promise. But it was the day. It totally changed. Hidden front. All right. But a rainy weekend is still better than no weekend, right? All right, children. Any other questions? Go forth and outline.